Hi, my name is Katherine Southard. I'm an estate planning attorney in New York and California. And today I want to do a quick webinar just to see if I can answer some questions and go over the most common estate planning mistakes that I've seen in my practice. I hope this will be helpful to everybody. If you have any questions, you can email me at ksouthard@southardestateplanning.com, or you can email my assistant Lauren at lauren@southardestateplanning.com. That's LAUREN. So let's get started. If you have any questions, you can type it in the chat and I'll do my best to answer the questions at the end of the webinar. Okay, why is estate planning important? I'm glad that you're all here. I'm sure you have questions, that's why you're here, but estate planning is important because it gives your loved ones, your family members, your children, spouses, friends, a comprehensive plan which will ensure how your assets are managed and distributed, and healthcare, how you would like your healthcare managed in your incapacitation. So basically, it gives your loved ones mostly peace of mind. Okay, the number one estate plan is really not having an estate plan. So a lack of a will, failing to create a valid will. A lot of people will handwrite a will and have the false sense of security that they have an estate plan, but not all handwritten wills are accepted. Certain formalities need to be followed in New York and California in order to make it a valid will. Not updating a will. A lot of clients will come to me initially about a family member, say we're in probate and I'm handling their parents' estate, and I'll ask them if they have a valid estate plan, and they say, yes, we have a will. We did our will 15 years ago. So a mistake in estate planning is not updating your will. It's great that they took the initial steps to create an estate plan, but then you really need to keep it current. So neglecting to update the will after major life changes. So what are some major life changes? A new marriage, a divorce, birth, so you might have additional children, any deaths in the family, a spouse passed away and you didn't update your will, or a disability. So we want to provide and care for anybody under a disability and make sure the assets go to the correct people. So it's good to periodically review your will and your estate plan. And hopefully you do this by having a relationship with an estate planning attorney. This is a big one, ignoring healthcare directives. I do get a lot of people that come to my office and they want a will or a trust, but they don't feel that their healthcare directives are important to cover. And I think this is for a variety of different reasons. It's hard to think about your own illness or the fact that you may be incapacitated, especially if you have young children at home. It's hard to even comprehend that you may be incapacitated, who would care for them, who would make decisions for you. But the consequences are, if you don't have a healthcare directive, somebody else will be in the position to make these healthcare decisions for you. And it could cause a lot of family fighting and conflict. And sometimes the court have to get involved. Working with an attorney, we would go over who are good options for your healthcare agent, who could make decisions. You know, sometimes people come into the office and they want to nominate an uncle in a different country, and we talk about the time differences, and we try to come up with someone who's local and they're able to come to the hospital or speak with doctors within the same time zone. Neglecting financial and legal records. So failing to organize and share financial and legal information. If you do have an estate plan, or even if you don't have an estate plan, it's good to categorize what accounts you have. Where are these accounts? Often people will come into my office again. We'll be going through the probate process, usually for a family member, a parent, and I'll ask them, do you have a list of their assets? They don't have a list of their assets, and then they have to go through their personal belongings. They actually sometimes have to go to local banks and try to figure out if their parents or loved ones had an account, and that takes a lot of time to try to figure out what the assets, there could be pensions involved, bank accounts, investments. So that's a delay in an estate settlement. And it just creates, again, a lot of conflict within family members. Often when you're going through the probate process, for example, one sibling has more money than another sibling. So this settlement could mean a lot to the second sibling, where it doesn't mean that much to the first sibling, and they can take their time. So we can avoid that with a comprehensive list of your assets in the estate planning process. Not considering tax implications. So in New York and California, two very different states, two very different implications. New York has what's called the cliff tax. So if your estate goes above a certain amount, the whole entire estate is taxed. In California, they do not have estate tax, so those concerns are not there. However, both states have the federal exemption, which is due to go down. So in the estate planning process, we always want to look at the tax implications of an estate and the estate plan and how we could minimize those tax implications. Not utilizing trusts. You know, some people don't understand what a trust is. It is confusing. They get nervous because when you create a trust, you transfer assets into the trust, and it can seem scary at first. Am I losing control of these assets? Not always. Unless we're doing some advanced tax planning, most trusts are revocable until you're passing. So it's good to speak with your attorney and see what are your options as it pertains to trust, because trusts are very valuable in avoiding probate. And I, in New York and California, an attorney in New York and California, my goal is often to avoid probate. Probate is a public process, and all of your confidential information gets out. And right now we're seeing a lot of fraud. I was just speaking to my assistant about a situation that we had. We have a probate filed in New York County, and you have to list all the liabilities. And some random person went and looked up their record, and now we're getting all these fraudulent letters to settle this account and getting harassed by phone calls, which is very unpleasant for the child of the deceased. So we can avoid all of this. We can keep the estate planning process private. When you pass, we can keep everything private by using trust. We can avoid probate, which can cost up to 8% of the entire value of the estate. So I encourage you to look into trust and see what the benefits are. So again, I went over this a little bit, failing to plan for incapacity. So this would be your healthcare decisions. What kind of healthcare would you like? Would you like a nursing home if you're incapacitated? Would you like to die at home? I know these are very difficult conversations to have with your loved ones, but they're also very important. So your siblings or your children or your spouse, if you're in a second marriage, everybody may have a different idea of what you would want because they know you best. In reality, if you don't have these conversations or you don't have the legal document in black and white, then nobody really knows for sure what you would want. And it can create a lot of complications with your loved ones. And we can avoid that. Unequal treatment of beneficiaries. Sometimes this happens unintentionally. Sometimes you have to create beneficiaries different. So for example, if you have one child that's under a disability and one child that's not under a disability, often we will try to allocate a lot of the funds in trust for the child under a disability to make sure that they are cared for. If you do treat beneficiaries different, it's good to either, I say, leave what's called a love letter. It's not a legal document, but you can leave an explanation. I treated this sibling different, or I treated this child different for reasons A, B, and C. And sometimes, you'll come into an office or you'll be working with an attorney thinking you want to treat your beneficiaries different for a variety of reasons. And then after talking through the reasons with the attorney, you may come to a different conclusion. So it's good to have a legal professional that you can bounce ideas off and discuss the pros and cons of setting up a plan to treat beneficiaries differently. So not seeking professional care. Everybody's Googling options now. It's very common. I even do it myself. If I have like a scrape and it's getting infected, I'll Google like scrape, getting infected, red, inflamed. We are all Googling different options. That's okay. I think it's a really good place to start, actually. If you've never had an experience with an estate plan, Google it, look into it, research it, but no, it's not the final best way to do things. And you could be getting incorrect information. It's a good place to start, but then look for an attorney that you could trust and work with. And the best way to do that is to speak to friends, colleagues, family members, and see who they used and why they liked the attorney. And that's it for my presentation, but I do want to answer some questions because they came in, and there's some pretty good questions. The number one, the question that keeps on popping up is deeds. So if I want to leave the house to my child and I want to protect it from creditors, can't I just put number one, my child on the deed now, or can I just transfer the house to my child now? That is the number one mistake I see over and over and over again. And it is a problem. Do not do that. Speak to an estate planning attorney or a tax attorney before you do that. In California, there are tax implications which could cause a reassessment. And in New York and California, you also lose what's called the stepped up in basis, which is basically if your parents bought a house for $10 and the house goes up to $100,000, when they pass, if they leave that to you in a trust or will, you take the ownership at $100,000. And if you sell it, there's no capital gains. If they transfer it to you during their lifetime, you lose that stepped up in basis. So you would pay a very big bill for capital gains when you sell it. That's number two. The third and most important reason is if you put your child on your deed, or you as a co-owner, or you just remove yourself and put your child on, it's considered a gift. A tax return has to be filed. But more importantly, all of their creditors would have access to that asset. Or if they get a divorce, it's part of their divorce then. So you don't want to do that. Another question is, if I did a will many years ago, but I want to change the gifts that I leave to certain people, can I just handwrite these gifts on a separate piece of paper? You cannot do that. Most likely it will not be acknowledged within the court. So in order to change the gifts, you would do a codicil to your will and follow the formalities of the state of signing and witnessing the will, depending whether you're in New York or California. I'm only specifically speaking to New York and California because that's where I'm admitted to practice. So it is important to have a relationship with your estate planning attorney. With my clients, we touch base at least once a year, sometimes more. And I encourage you to email with questions and stay in contact with me and let me know if anything major has changed in your life. So, okay, so can my young adult child be guardian of my younger children? This is very common. So you have a 24-year-old adult and you have minors, say 7 and 14 years old. So if something were to happen to you or you and your spouse or you and your partner, could that a young adult child then be legal guardian of your young children? Yes. Technically, you only have to be 18 to be legal guardian. And I know it seems like this is the natural first selection because it's family, but I ask you to pause and we would work through this in our initial meeting. Often a young 19, 22, 24-year-old, 26-year-old, they're just trying to get their life started. And for them to become legal guardians of minors that are still in elementary school, they would have to really put their life on hold, and it could be tremendously stressful. Let's talk about if there are better options out there for you and your family and your minor children and your young adult child. And we've hit our 15 minutes. If you have any more questions, again, please email us. Our email is right here on the webinar, ksouthard@southardestateplanning.com or Lauren@southardestateplanning.com. Thank you.